separated by 4 miles and 313 days. The initial burst of gunfire was on January 23rd of 2010 in Old Sun City, when this defendant was driving his ice cream van, and he was pulled over and robbed for $12 and shot multiple times, suffering serious injuries. Serious injuries which required medical treatment, surgeries, therapy, which affected him physically and mentally. This 39-year-old man had to move back in with his parents and live in a hospital bed in the dining room. As he told Detective Schramm, he prayed every day that the people that did this would be brought to justice. Those prayers went unanswered. The investigation went cold. Nobody was apprehended. He became frustrated. That frustration led him to start his own investigation. His investigation, I suggest to you, which occurred over several months, became an obsession, where he's asking people back on the street for information. He's asking Norma Jean Towers to assist him when they drive around South County in Hispanic neighborhoods, where he's wearing a hat and ducking down and calling out license plates, where he's doing internet searches, accessing inmate records, accessing Hillsborough County Sheriff's Office. Because his prayers for justice turned into an understanding and a search for vigilante justice, where he chose to take it on into his own hands. Into his own hands with a semi-automatic pistol. And 313 days later, after he was shot, he showed up at the residence of the Lucas family at 604 Ocean Mist Court, armed with a firearm, demanding to know who or where Creeper is, demanding them to produce identification, and then shooting 6 of the men, causing the deaths of Sergio Guitron, Juan Guitron, causing the permanent disability of Richard Cantu, injuries to Daniel Beltran, Ramon J. Galan, and Gonzalo Guevara. Jose Rodriguez escaped uninjured. The issue before you is not, did this occur? The issue before you is, who did it? The state submits to you that there is overwhelming evidence of this defendant's guilt, of his identity as the perpetrator, not just in the identifications conducted by Mr. Guevara and Jose Rodriguez, but by other direct and circumstantial evidence in the record. The urgent rush to paint that van the very next day. The ballistics, the unique ballistics in this case. Projectiles and casings from the crime scene, matching projectiles and casings from the Keetley property. Now there's an anomaly. Casings came from a Glock. projectiles could not have been fired from a Glock. I anticipate you'll hear from the defense that that tells you the ballistics assessment by Jennifer Clark is wrong. It doesn't make sense. It absolutely makes sense. It's very easy to swap out the barrel. And in fact, the fact that there is an anomaly strengthens the impact, the weight of that circumstantial evidence. Because you have both casings from a Glock and projectiles from a non-Glock barrel at both scenes. The fact that there is that anomaly at two different scenes, the scene of the murder and the scene of the Keetley house, strengthens that tie, strengthens the identifications, and points to this defendant. Now, the way the rules of procedure that govern any trial in the state of Florida play out is that in a criminal case, the state having the burden of proof, we have the benefit of addressing you twice. Now at the outset, and then in the rebuttal of Ms. Gowdy's statement to you. So I'll have a second opportunity to discuss with you in detail what I submit and will suggest to you the credible evidence is sustaining and supporting a guilty verdict in this case. But at this moment, I'd like to talk to you about something unrelated to the evidence. You will be given jury instructions by the judge, which of course is the law that you're to apply. In those jury instructions will be a verdict form. And in this case, because there's 6 counts, and because you will be given several options, and then you will have to make specific findings, it's rather detailed. And the judge will read it to you when he reads the instructions. But by law, the question for you to answer is not just guilty or not guilty, but you will be given guilty, for instance, as to the murder counts, guilty of first-degree murder, guilty of second-degree murder, guilty of manslaughter, or not guilty. As to the attempted murder counts, guilty of attempted first, guilty of the lesser of attempted second, guilty of attempted manslaughter, or not guilty for those counts. And there are special findings that you have to make if you find the defendant guilty as to whether there was a use of a firearm as to each count. I suggest that to you and discuss that with you today without conceding that this is a crime of a lesser crime. I do not concede that. But there is no real instruction or description of how you go through this form. But you will be told by the court, I anticipate, that you should return a verdict of guilt for the highest degree of crime that has been proved beyond a reasonable doubt. And what I suggest that means is you start from the top on each count, and your knowledge should be, have the state proved beyond a reasonable doubt, guilty as charged, and then you go down the list. Okay? And then if you find a guilty as charged as to any count, you have to look at those questions, special questions as to use of a firearm. I know this is boring and dry and it doesn't really go to the evidence, but you won't see any explanation of that in the jury instructions. And how you proceed back there is something that we don't get involved in, because that's up to you after your foreman is or person is selected, and you determine how to proceed. So at this time, I will ask you 2 things. I will ask you to base your verdict upon a review of the entirety of the evidence presented to you, and ask you to engage in your jury deliberations with an open mind, respectful of one another's opinions, and coming to a verdict that you know you can live with in your head and your heart. I am confident that when you analyze the evidence in its entirety, not piece by piece, separate by separate, you give consideration to everything, of course, but look at the whole picture. Consider everything in its entirety. Consider what is reasonable in your life experience and your judgment. And I suggest to you that if you proceed with your analysis in that fashion, you will return verdicts of guilt beyond a reasonable doubt, as charged, to these 6 counts: guilty of first-degree murder, guilty of on 2 counts, guilty of attempted first-degree murder on 4 counts. Thank you for your considered attention. I ask you to extend the same to Ms. Gowdy when she addresses you. I'll have another opportunity probably this afternoon to address you again. Thank you.
Ladies and gentlemen, we're going to take a very short break before we proceed to the defense argument. So please do not discuss the case amongst yourselves or with anyone else. Please do not do any research related to the case. And please do not be exposed to any reports of the case outside of the courtroom. All rise for the jury.